He essentially says that I can't believe the testimony and discredits the testimony in key respects by suggesting that there is at least the appearance of a conflict of interest, yet nonetheless believes that the public interest is served by allowing Fani to proceed despite all the powerful evidence of her corruption. I don't buy it. First up is the breaking news, or it was breaking earlier today, that Fani Willis is allowed to stay on the case against Trump, thanks to what essentially is a free pass given to her for misconduct by the judge, Judge McAfee. And this was my initial response to Judge McAfee's ruling. It will hopefully guide this, I think, for this discussion. Let's put up that tweet. McAfee failed to uphold the rule of law today and effectively ratified outrageous and likely criminal misconduct by Fani Willis and others associated with the sham prosecution of Trump. Nevertheless, Trump has largely been vindicated, as most normal Americans see through the judicial legerdemain, and have further confirmation of the political corrupted nature of the Get Trump election rigging scheme by Democratic Party politicians and their minions. So the judge essentially found, it looks like, he uses different language to describe it, that we can't believe anything that Fani Willis and her boyfriend, Nathan Wade, said about their relationship. And he doesn't think there's enough conflict of interest, specific conflicts of interest, to warrant their disqualification or Fani Willis's office's disqualification. He did think there was an appearance of impropriety in the least, the appearance of a conflict, and I'm not quite sure what the difference is as a practical matter, but that's what the judge ruled. And so he said, and let's go to the key part of that ruling. This was his key finding. There has not been a showing that the defendant's due process rights have been violated or that the issues involve prejudice the defendants in any way. Nor is disqualification of a constitutional officer necessary when a less drastic and sufficiently remedial option is available. The court therefore concludes that the prosecution of this case cannot proceed until the state selects one of two options. The district attorney may choose to step aside, along with the whole of her office, and refer the prosecutions to the prosecuting attorney's council, which is a state entity, for reassignment. Or alternatively, SADA, I guess Special Assistant District Attorney Wade, can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration distracting from and potentially complicating the merits of the case. I think this is an absurd and outrageous ruling. I don't know how else to describe it. He essentially says that I can't believe the testimony and discredits the testimony in key respects by suggesting that there is at least the appearance of a conflict of interest, yet nonetheless believes that the public interest is served by allowing Fani to proceed despite all the powerful evidence of her corruption. I don't buy it. And in the beginning of the court's decision, which I think we'll link below, he highlights what the basic rules are for how courts are supposed to protect the administration of justice, the administration of the law. And this is a decision from the Georgia courts. The administration of the law should be free of all temptation and suspicion, so far as human agency is capable of accomplishing that object. The administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice. And later in the decision, the court found that despite all the evidence that you saw, and I don't want to belabor it, but it's pretty clear that they lied to the court about the nature of their relationship. Wade lied under oath, it looks like, about what his relationship was with Fani Willis. They lied about when they started it, and the court just sloughs all of that off. Ultimately, dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud of impropriety and potential untruthfulness. And he said, well, I can't get into whether all the witnesses were specifically lying or not. It would just be too much work. I'm paraphrasing, but that's essentially what he says. So this was a political decision in the sense that he protected the Fulton County's prosecutors from what would be obviously for them the terrible removal of them from prosecuting Trump and others, if not in addition to throw out the case in its entirety. Now, I don't know about you, but I believe that when you have a prosecutor messing around with her boyfriend in an adulterous relationship, if I recall, he was still married, there are questions about whether there was favoritism in his hiring. There are significant questions, and it doesn't have to be proven to a shadow of doubt. I guess the standard was preponderance of the evidence, which is, I always kind of see it as 50 plus 1, right? Just a little bit more than a little over 50% of the evidence or certainty. That's my layman's analysis of it. That they were lying and that they were benefiting financially. I mean, he goes through, the court does, again, all this kind of throwing smoke up, saying, well, they were splitting their costs of their trips together. Well, did he stop to think, does the court think that, well, maybe Nathan Wade wouldn't have been able to go on the trips at all if he didn't have the job? And he highlights the fact, well, he only gets $250 an hour. Lawyers all the time are happy to take a discounted rate if they're certain that there'll be a certain amount of work. You get essentially hired for the project. Obviously, you can work hourly, but there isn't a lawyer or a few lawyers that wouldn't take a certain number of hours at a lesser rate versus hoping they get basically unknowable amounts of hours at a higher rate. A bird in the hand. So the court just ignores all of that. And the court also ignores her outrageous statement at that black church, essentially accusing the defendants of racism for raising what we now know were well-founded questions about her ethics. It's what's called forensic misconduct. Now, the court yells at Fani Willis about this, but all these reports or court opinions that criticize prosecutors or criticize government officials in the case of special counsels, or IG reports that criticize people where there are no consequences to the criticism, forgive me for not being terribly impressed. I mean, here the court essentially confirms that Trump and the other defendants have been victimized by two people who were pushing a case in a way that benefited them financially. I mean, the court says, well, there was no evidence that they were trying to extend the case in order to extend the payments to Nathan Wade. Well, how about the idea that maybe the case would never have been filed or pursued if they didn't have the relationship? I mean, as someone commented on one of the social media platforms, the court essentially found, he didn't come out and say they lied, but he said it in so many words. He didn't want to go there directly, but that's the inescapable conclusion from his order. We can't have two liars prosecuting, but we can have one liar. We can't trust these two to prosecute, but we can trust the one, despite all the evidence of misconduct. And perjury? There should be a perjury investigation against Fani Willis and Nathan Wade, among other criminal acts that they may have committed in this scheme against Trump. And it's further indication, as I said earlier, about how corrupt this targeting of Trump is. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.